You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. You guys, that clip is so funny to me. I don't know. If I am having a bad day, that clip always makes me chuckle just a little bit. Hello to everyone. My name is Pam Esquire, also known as your law intellect and also your social media lawyer. How is everyone doing this Good Friday? Hello to everyone. You guys already had about 50 likes before I came in here. So let's keep up the momentum. Make sure we hit the like button. Subscribe if you haven't done so. Of course, welcome to all of the new subscribers. Let us know in the chat if you're new so our mods can give you that proper introduction. And welcome back to all of, my day ones. That is so funny, right? He like... Oh, he says, "Job turkey." Hilarious. That clip will forever make my day. What's up to everybody, to my mods, of course. Also, Shanice, Toy, BB, Thomas, CBBJ, Cynthia, Linda, Tasha. Yes, I am your social media lawyer. And let me tell you how true that is. I'm going to tell you in a minute. Lady Prophetess Deborah Jones, thank you for gracing us with your presence. Tiffany, thank you so much. Alice, thank you so much. Of course, Dev. Yes. That's my ace right there. Joyce Johnson, thank you so much. To all of you guys that have come to join us on this fine Good Friday. I just have a few updates for you guys, and we just gonna kick it for a minute. We might be here for a few minutes because I never talked about the government's response to the motion to suppress. So if we can get through that, because they've been going back and forth. It was a reply, was a sir reply on whether that motion to suppress should even stand. But what I want to start off by letting you guys know is, so I ended up back in New York earlier this week. It was not planned. To me, it wasn't planned, but everything worked out pretty good. So while we were down there at the barbecue place, downtown Brooklyn, I said, well, let me go on in and I'm going to check out the status conference for the robbery case. Maybe I could run into the bishop, take a selfie or something, since he won't come on my platform. And I said, this is going to be pretty dope. Usually status conferences are real quick. So it's about calendaring. But because Saquon he asked the day before to entertain bond to get out, because Saquon is the one that's still in jail right now, awaiting bond or the trial. And Jawan Anderson has been out on $50,000 bond since he was arraigned. So what was funny, guys, right? I walk up, go up to the court, and everybody, it was a couple people was like, "Hi, you're that young lady on the internet. What are you, the law intellect?" I just like almost fell out. I was almost nervous because I'm like, wait, what? I'm just a little YouTuber over here. Like, what are you talking about? So they were like, "We know you." Like, I was really somebody. So my husband's gonna say, "So you're YouTube famous now?" I was like, apparently we're getting notoriety around the country, at least in New York. So I go into the court and walking up in the hallway or whatnot, and I'm sitting there, and it was the status conference was for 3 o'clock. So we're sitting there. So while I'm waiting, I meet Jawan Anderson's family, like his mom was there or whatever. Shout out to them. They watch as well. She even made the comment that she wasn't, getting, I guess, maybe the adequate definition as far as why, or the reasoning, I should say, as to why this was in federal court. And she was able to kind of discern that from one of my videos. I thought that was pretty cool. I'm out here, teaching people, what's going on. So that was pretty dope. She's very nice family. Um, of course, Jawan was there, and trying to figure out how much I should say. So we talked extensively. So I can't wait till this trial is over because the stuff that the few people that I met there, they wanted to tell everything, And I'm still a lawyer first, guys. So I know you guys want all the scoop when it comes to that conversation, but I think their defense of this whole entire robbery, I can't put it out there. But there's a couple of things that if I'm able to verify independently just from public record, then I'm definitely gonna bring it to you guys. But I was like, I understand, I appreciate you feeling comfortable talking to me or whatnot, but I'm not gonna say anything about what you say. But they got a defense. Let's just put that there. They have a defense to this case. And it's gonna be good. So, anyways, no, I'm definitely not going to yeah. So anyways, so we're sitting there and it's like 3 o'clock again, and I'm thinking, okay, we're gonna be in and out of here. We're just gonna hear what the dates are, if they're actually going to have the trial in July or not. So 3 o'clock come, we're all looking around. I'm like, dang, okay, 3:15, 3:30, we still just sitting there. 4 o'clock come. Like what? Like what is happening here? Why is it taking so long? Literally a status conference. All you do is kind of just what it says. You give an update on the case. If the trial is still going, if you need more time, when is the next status conference to see where everything is. So what happened is, because Saquon was attempting to get bond, he's incarcerated. So I assume they just have to wait until he was able to come up, like they had the marshals to be able to bring him up. So he was actually at that status conference as well. So he came up, and his family, they were very interesting people. So he had a couple of people that came in, and I already knew where it was going with it because they were kind of loud just a tad bit. So this was before the judge even came out. They was kind of loud, just saying certain things, and the family was like, "Shh, stop talking, stop talking." And so it was very, very, very interesting because I already knew as an officer of the court, I was like, yeah, this is going to be a very interesting type hearing with people talking in federal court, because federal and state court is totally different. Federal court doesn't allow you to, they always tell you like them shenanigans you do in state court, we don't do that here. And the judge actually did say that in this case. What time did the judge even take the bench? The judge took the bench at 4:30. That's when all of this started. So the judge takes the bench and he reads the letter that I read to you guys in the last video. the judge was like, going through everything or whatnot, and was like, so, and he has this really, really deep, like, after dark voice. So it's like way down in the basement. Like James, is his name James Earl Jones? Like it's really, really deep. So he sits there, he reads the whole letter, and so then he asked the government, like, hey, what do you think about him wanting to get on this bond? The government was like, well, nothing has changed. In our opinion, nothing has changed. There was this alleged robbery on videotape during Sunday worship. It was brazen, da 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 da. So really nothing that she felt the defense can come with to say that he, should be released. And essentially was saying, there's a difference with Jawan, who didn't have this history, but allegedly Jaquan Polak, Saquon Polak, I guess he was out, he hadn't been out too long or something. He had done a bit for robbery before. So she was obviously waiting. She like, whatever, it ain't nothing you gonna come with in order to convince me that we should agree on him being out on bond. So she went over the same stuff that she probably said in all the other 2 hearings that they denied bond. So then the attorney gets up, the attorney for Saquon gets up, and he's like, he starts to get up. So then all of a sudden there's an outburst, like in the courtroom. So of course it's like one of the people that came in for Saquon. So they got loud and said, so okay, I'm gonna be quiet now. I'm gonna be quiet, don't worry. So the judge was like, yeah, just get him out of here or whatever. So one of his people get kicked out of the courtroom. So the judge says, does anyone else want to play Donald Trump Jr. and mouth off in this federal court? We don't do this here. This is not state court. He said, does anybody want to do the Donald Trump Jr. and get kicked up out this joint? So anyway, she ends up getting removed. Then she's like sticking her head through the door. I just want to hear. Can I please just hear what's going on in here? So then, of course, the marshals is telling her she got to be outside the door. So after that fiasco, the defense attorney gets up so he can argue bond. Yes, Donald Trump Jr. So the defense attorney comes up so he can argue bond. So then the defense attorney gets up and he's like saying the nice things about your client. We call it allocution, where you talk about the great things they did before and blah, blah, blah. So the attorney essentially talks about the video and says, there's how did he word it? He kind of, the way he worded it was that it was perceived robbery or something like that. I don't quote me, but he said something as if like it was so the judge cuts him off and was like, did it look like a robbery to you, counsel? Are you saying that it really was a robbery? Or are you saying it was something else? Was it something else, counsel? I was like, oh, this is about to be good if he responded say something like, well, since you asked, Your Honor. But no, the attorney was kind of sitting there like, how do I answer this question? So he was like, no, counsel, we're not playing games. I want to know, did it look like, when you looked at that video, did it look like a robbery happened to you? He was like, he said, did it look like a robbery or did it look like play to you? I think people in the gallery wanted to be like, can I answer that question? But no. So he kind of like rephrased what he was saying. It was like, obviously he's not, you don't even put your client there, like your client's not even there. So it was just kind of like, Your Honor, what I'm trying to say is, so he tried to word it in a way where it was like, so he can get up out of this question. So he said, well, Judge, I'm about to answer your question. Judge was like, yeah, answer my question. Answer the question right now. Like, I want you to counsel right now. I was like, dang, this judge is a beast. He was a beast. He was like, listen, he is law and order. That's just what it is. He was law and order. He's like, no, counsel, right now. That's nice. You told me about your client. He enrolled in college 2 weeks before. He was going to be some Marine, something or other, somewhere, which is some unique profession. That's cool, but I want you to answer the question. So he kind of found a way to kind of finagle his way around that question. You know, you don't put your client there, period. And then the judge kind of let him move on from it. He's like, okay, that's what I thought. That's kind of what I like, dang. And Whitehead wasn't there. That was another thing that I was told by a couple of people. They said he typically showed up for the last 2 hearings, but he didn't show up for this one. I was like, dang, why he don't want to show up when I come to it? I wanted to, see if he wanted to talk to me like he talked to the Shade Room yesterday or the day before, whenever he went and did that interview. We can go over that too. But yeah, I was like, oh, okay. So the attorney started talking about how Saquon was basically a very smart guy, and they all met. They had like a defense meeting where both of the defendants were able to come with their attorneys, and how basically Anderson, who's been out on bond, is a representation of how you can successfully be out on bond and be fine, because Anderson is doing well. He's in all these programs. And so he was kind of using him as the poster example of how Saquon can be. He's going straight to his mom's house. And then the judge intervened. Counsel, I'm going to stop you right there because I don't want you breaking attorney-client privilege. Now you're saying what happened on the other side, and I don't want you breaking attorney-client privilege. I think you're getting a little bit too far to the left talking about conversation that you had. So that judge was not playing no games. I was just like, oh, wow. So he was like, yeah, Your Honor, I'm not trying to do that or whatever, but I think, I think that my client should get a fair shake. He was denied a couple of times before. And then in response, I guess the government gets up and pretty much was like, again, there's nothing that really changed. This was a dangerous situation. What occurred? He was convicted of this prior to, like, a robbery, allegedly, I guess. And she said pretrial services that kind of assesses the risks. They were like, yeah, there's nothing that we can do. It don't matter, tether, all of that. They know all the options, and they didn't think that Saquon should have any of these options or whatever. So of course the family was looking all distraught because it wasn't looking too good. And then the judge was like, okay, well, I'm gonna take it. I'll revisit this, or kind of like take it under advisement. He didn't make a decision right then. And then the defense attorney started talking again. He was like, counsel, that means this is over. It's like, dang. So that was like the whole bond situation. We don't know yay, nay, which way it's going to go. So I'm assuming he's going to do an opinion in order to see if Saquon Polak can get out. I thought it was the way they did the footnote, as if it was some new significant information they had. I was trying to listen to see what that was. That's kind of really why I came, because I know a status conference isn't much of a date. But it was worth it, just meeting the people and seeing like Jawan's family. Like I said, they seemed like really nice people. He seemed like a decent man, young man. And then like I think Saquon, it sounded like he was in foster care. So we had like adopted family there, and then I guess his biological family was there. And apparently every time he's had hearings, his family has been there, to support him. But it was like opposites. They was on different sides of the court, of the gallery. They were like on different sides of the aisle. So yeah, that was that. And then so what ended up happening, we've all been trying to wait for this trial date. Everybody is dang near booking their flights. And they moved the date. They moved the trial. But you guys are not going to believe this date. The date for trial has been moved to March 2024 for this robbery. I have my suspicions why it's so far away, but I don't want to put it out there. But yeah, it's been moved to March 2024, and they said that it's so they can reach some. They're in discussions for pretrial resolution. And that's that. But what I will say is, if some of the stuff that I was told by some of the people that were up there, uh some of these videos that Whitehead has done, like when he talked about the robbery and the people and some of the statements he made, they're going to end up being contradicted if what they're saying that they have is really like for real what they have. That's all I'm saying. It's going to be his word, him being his stuff probably being used against him as it's been in all these other pleadings and complaints that we've looked at. So that's that. So then we have the next status conference is June 28th or something. Let me see. So the trial is March 11th, 2024. Yeah, June 28th at 1:30 is the next hearing date. So that was that. So anyway, on our previous video, a couple of videos ago, we talked about the motion to suppress. Now, one of the things when we look at these motions, we learn a lot of facts because they have to apply facts to the law. So that's why I like going over them, even though sometimes they seem a bit boring and a bit redundant at times. That's why I skip over some of the law and just kind of give you the basics of what the law is, because it can be a bit overwhelming. But the facts are very, very important because we don't really know a lot of these facts. We only know what's in the indictment. So when they file these motions, we learn a lot of information, such as the search warrant for the church, for the GUNs, all of that. Like, we didn't know any of that until they filed the motions. So I want to go over, the government responded to the motion to suppress that Whitehead filed. Remember, he's trying to suppress the subpoenas, the warrants, whatever, that saying that everything they captured is the fruit of the poisonous tree, which is real similar to what he was saying in the first case that he had, that he argues that they were illegal search warrants and all of that. He's trying to get these search warrants suppressed, saying that he asked for a lawyer and that they still talk to him anyway. So the government has responded, and then Whitehead has replied, and then today the government did ask the court for what's called a reply. So they replied to their reply, which, it's up to the government, to the judge, the court, if they're going to accept that. So yeah. So you said, honestly, they should drop the case against the alleged robbers. They were coerced and set up to be used. Okay. He should have shut his mouth. Now it'll be Whitehead versus That's a true statement, because, and I was going to play the videos. Some of the videos that he had that I have, that it appears they're saying they have, again, I don't have this evidence, but they're saying that they have certain things. Is going to be contradictory, which means I don't know why he even came out and talked about it at all. Perhaps that's why he said, well, I'm not going to talk about this robbery anymore, when before he was like, I'm going to be sitting there every single day and I'm going to look them dead in their eyes and all of that. And then all of a sudden it was, I'm not going to worry about them. God forgave them, I'm going to forgive them. And it was like, where did all this change of heart come from? Take a couple more comments. No trial would be needed because Whitehead will be in prison. They'll probably stay. Well, Andre said we'll see a superseding indictment for insurance fraud with the stage robbery. These are all opinions, guys. This is all opinions. Faith Speak says, I knew that they still investigating the rabbit hole of the fake robbery. They're definitely investigating the entire situation. Now, what their conclusion is, The government definitely didn't give that impression being there. She basically was very clear that this was a heinous crime and it happened in the worship service. And that's why she didn't agree for Saquon to be out on bond. So the next time this dude is a pathologic, not to mention lying to the feds, lock him up already. Well, today he said he got his smile back. Oh, did he? Did he? Okay, he might not want to smile too soon, but hey, who am I? So let me see the government's reply. I have so much stuff. So this is the government's, they've replied to the motion to suppress. You see they have their table of contents. And so their preliminary statement is, as explained in the superseding indictment, this case involves Lamar Whitehead's multi-year effort to enrich himself through threats and falsehoods and to conceal evidence of his fraud schemes with further false statements. Specifically, in 2018 and 2019, Whitehead used fabricated bank statements in an attempt to obtain various loans, including a business loan and a mortgage. Indictment paragraph 2. For these fraudulent statements, Whitehead is charged in count 5 with wire fraud. In 2020 and 2021, Whitehead convinced an individual, victim 1 and her son, to lend him $90,000, which he falsely explained that he would use to assist victim 1 in obtaining a home. Instead, Whitehead used the money for his own purposes, including to purchase luxury goods, paragraph 3. For these fraudulent statements, Whitehead is charged in count 1 with wire fraud. In 2022, Whitehead used threats to attempt to extort money from a businessman, victim 2, and also attempted to convince victim 2 to give him $500K and take a stake in certain real estate transaction by falsely claiming that Whitehead would obtain favorable actions from the New York City government. For these fraudulent statements and threats, Whitehead is charged in count 2 and 3 with attempted wire fraud and attempted extortion. And also in 2022, when law enforcement executed a search warrant for cell phones on Whitehead's person, Whitehead falsely denied possession of more than one cell phone. Paragraph 6. For these fraudulent statements, Whitehead is charged in count 4 with making false statements to law enforcement. Whitehead now moves to suppress statements he made to law enforcement and dismiss count 4. He also moves to suppress evidence gathered from executing many of the search warrants obtained in the course of the investigation, and he requests a Frank's hearing regarding victim 2, his described in warrant as CS1. Their challenges should be rejected. Whitehead was not in custody at the time he made material false statements to law enforcement, so there is no basis for suppression. His challenge to the search warrant fails at each turn. He lacks standing to challenge the warrants. His challenges are otherwise largely conclusory and identify no error in the magistrate judge's finding of probable cause. And in any event, the government relied on the warrants in good faith. Finally, there is no need for a Frank's hearing for multiple reasons, including that a Frank's hearing is not a basis to challenge a non-affiant's credibility, and that the search warrant affiant did not ask the magistrate judge to rely on CS1's uncorroborated statements. The very facts Whitehead identifies as requiring a Frank's hearing show the opposite. The affiant acted with kinds of good faith and care that Frank's endorses. Oh, goodness. Whitehead has been shooketh lately. That's what I'm thinking as well. His wife had to know. Okay, let me get focused here. Whitehead's motion to suppress his false statements to law enforcement should be denied. Whitehead moves to suppress the false statements underlying count 4 of the indictment as having been taken in violation of defendant's rights. The defense argument appears to be that, despite never being placed under arrest, Whitehead was in custody as soon as his interactions with law enforcement commenced, and that as a result, after Whitehead told law enforcement that he did not want to speak to them without an attorney present, law enforcement should have ceased speaking with him. Whitehead's argument in the alternative that even if he was not in custody and even though law enforcement was not required to Mirandize him, the rights mentioned in Miranda still apply. These arguments are contrary to black letter law and should be rejected and the motion denied without a hearing. Relevant facts. This is when you get into the facts. That's what I'm talking about. On June 7, 2022, the Honorable Michael A. Hammer, United States Magistrate Judge, District of New Jersey, issued a warrant authorizing law enforcement to seize all Apple iPhones on Whitehead's persons, including in any garments worn by him or any bags or containers carried by him, and to search those devices. Well, dang. So it wasn't a search warrant for the house. It was just they were able to go in and specifically search for these phones. Attached as Exhibit A is a declaration from Special Agent Thomas Ford of the Federal Bureau of Investigation, who participated in the execution of the Whitehead personal warrant the following day. On June 8, 2022, 4 members of law enforcement were in 2 vehicles in the vicinity of Whitehead's home in Paramus, New Jersey, when Whitehead came out of his home and approached them. Law enforcement served Whitehead with the Whitehead personal warrant, conducted a pat-down of Whitehead for officer safety, and seized a single Apple iPhone from the Whitehead's pants pockets. Whitehead read the warrant and conveyed to law enforcement that he did not want to talk to them without an attorney present. Whitehead was then given the opportunity to obtain phone numbers from the seized phone. A member of law enforcement held the phone as Whitehead scrolled through it to write numbers down. At the conclusion of the process, law enforcement informed Whitehead that a separate search warrant had been obtained for Whitehead's church location in Brooklyn, New York, and asked Whitehead to assist with opening that premises so that forced entry would not have to be made. Whitehead agreed. So they're talking about the location, the event space. For approximately the next 20 minutes, Whitehead told law enforcement that he was attempting to make contact with someone who could open the Brooklyn premises. During this time period, Whitehead, whose movements were never restricted, came in and out of his home freely, coming outside to obtain phone numbers from the seized phones the law enforcement was holding while standing outside in the driveway and returning inside, ostensibly to make phone calls. When law enforcement asked whose phone Whitehead was using to make calls, Whitehead responded that he was using his 14-year-old daughter's phone. When law enforcement asked if Whitehead had another phone on which he could be reached so that the agents did not have to continue to stand in his driveway, Whitehead responded that he did not. When law enforcement asked a second time in sum and substance, quote, "You don't have a second cell phone that belongs to you that we could call you on?" End quote. Whitehead again denied owning another phone. Law enforcement then asked for the phone numbers of landlords for the Brooklyn premises, which Whitehead gave them. Law enforcement then left. At no time was Whitehead placed under arrest or told that he was under arrest. At no time was Whitehead's handcuffed. At no time did law enforcement draw their weapons. Other than the brief initial pat down of Whitehead, at no time were Whitehead's movements restricted. At no time did law enforcement enter Whitehead's home. Whitehead was arrested on December 19, 2022, and first appeared in court on the charges in the indictment on that date. Let's go to the affidavit of the agents right quick. So this is the affidavit of the special agent. On June 7, 2022, the Honorable Michael A. Hammer, United States Magistrate Judge in New Jersey, issued a warrant authorizing law enforcement to seize all Apple iPhones on Lamar Whitehead's person, including in any garments worn by him or any bags or containers carried by him, and to search those devices. On June 8, 2022, 4 members of law enforcement were in 2 vehicles in the vicinity of Whitehead's home in Paramus, New Jersey. I was one of those 4 members of law enforcement. Whitehead came out of his home and approached us. We served Whitehead with the Whitehead personal warrant, conducted a pat down of Whitehead for officer safety, and seized a single iPhone from Whitehead's pants pocket. Whitehead read the warrant and conveyed to us that he did not want to talk to us without an attorney present. We then gave Whitehead the opportunity to obtain phone numbers from the seized phone. A member of law enforcement held the phone as Whitehead scrolled through it to write numbers down. At the conclusion of this process, law enforcement informed Whitehead that a separate search warrant had been obtained for Whitehead's church location in Brooklyn, New York, asked Whitehead to assist with opening that premises so that forced entry would not have to be made. Whitehead agreed. For approximately the next 20 minutes, Whitehead told law enforcement that he was attempting to make contact with someone who could open the Brooklyn premises. During this time period, Whitehead, whose movements were never restricted, came in and out of his home freely, coming outside to obtain phone numbers and the seized phone that law enforcement was holding while standing outside in the driveway and returning inside, ostensibly to make phone calls. We asked whose phone Whitehead was using to make phone calls. Whitehead responded that he was using his 14-year-old daughter's phone. When we asked if Whitehead had another phone on which he could be reached so that we did not have to continue to stand in the driveway. Okay, we read all that in the brief. At no time was Whitehead placed under arrest or told that he was under arrest. At no time was Whitehead handcuffed. At no time did they, okay. All that stuff is the same. So basically the agent has said under oath that all this stuff is true. So we'll read what the Fifth Amendment allows. We're not going to read all of it, but the Fifth Amendment requires that prior to custodial questioning, law enforcement must inform a suspect of the right to remain silent. You have a right to remain silent. Anything that you say can and will be used against you. You have a right to attorney. You guys know all that stuff you hear on Law and Order and all the rest of the, everybody knows the Miranda rights. To be clear, Miranda warning requirements apply only to custodial interrogation. So when you're in custody, they have to tell you what your rights are, essentially. So we'll go through. The ultimate inquiry for determining Miranda custody is whether there is a formal arrest or restraint on freedom of movement of the degree associated with the formal arrest. And determining whether there is a restraint on freedom of movement of the degree associated with the formal arrest, courts look first to whether a reasonable person would have thought he was free to leave the police encounter at issue. If the answer is yes, the Miranda inquiry is at an end. On the other hand, if a reasonable person would not have thought himself free to leave, a court must ask whether, in addition to not feeling free to leave, a reasonable person would have understood his freedom of action to have been curtailed to a degree associated with formal arrest. Only if the answer to the second question is yes, was the person in custody for practical purposes and entitled to full panoply of protection prescribed by Miranda. So that's the inquiry. And then they go to the Sixth Amendment right to counsel. It attaches only at or after the initiation of an adversary judicial proceeding against the defendant. Suppression hearing. In the Second Circuit, a defendant is entitled to an evidentiary hearing on the motion to suppress only if the defendant established a contested issue of a material fact. So now let's go to the discussion. So those are the basic laws. If you guys want to go look them up, you've heard them probably on some of these television shows because they go through that in Law and Order all the time. They're always doing suppression hearings, albeit not typically how it goes. It irritates me because that's not really how it goes. They don't have ex parte communication and most things have to be on the record. But nevertheless, thank you, Thais. I appreciate it. Look at Thais looking out for me. Thank you. Discussion. Whitehead was never in custody on June 8th, 2022, and therefore there is no Fifth Amendment basis to suppress his false statements. That's self-explanatory. They saying he wasn't in custody, So therefore, there's no reason to even suppress his statement. There is no dispute that Whitehead was not, in fact, arrested that day. The motion nonetheless claims that Whitehead was in custody because no reasonable person in Whitehead's position would have believed they were free to leave. The only circumstances cited in the motion to support this claim that the agents began searching Whitehead's home and that Whitehead was told he could not leave are fabricated. Whitehead's home was not searched on June 8th. In fact, law enforcement never entered his home on that date. Instead, law enforcement remained in Whitehead's driveway. Moreover, other than the initial pat down for officer safety preceding seizure of the seized phone, Whitehead's movements were never restricted. Indeed, during much of the time that law enforcement was outside his home, Whitehead was inside his own home, undisturbed, coming outside to interact with law enforcement only to obtain phone numbers from the seized phone before freely returning to his house. Whitehead was plainly felt free to leave the presence of law enforcement, as he did so multiple times during the 20-minute encounter. Such freedom of movement is hardly akin to a formal arrest. Other notable circumstances undermining any claim of custody include that there were only 4 law enforcement officers present. Whitehead was never in handcuffs, and agents never drew their weapon. And then it has all of the case law that shows that for that proposition. The court further need not hold a hearing before rejecting Whitehead's Fifth Amendment claim because Whitehead has failed to submit an affidavit from a person with personal knowledge of the underlying facts. To the extent Whitehead is also attempting to make a Sixth Amendment claim, see motion 5, arguing that even if the defendant was not in custody, the rights mentioned in Miranda still apply. Such a claim is meritless in light of the fact that adversary judicial proceedings had not yet been initiated against Whitehead in June 2022. So basically, your Sixth Amendment right did not attach. He wasn't even indicted till December, and all this happened in June. So 2, the warrant affidavits demonstrated probable cause. Let's see. You know what? Okay. What you guys talking about? Somebody sings. Okay. Okay, I'm gonna get back. I'm getting distracted, and it's a lot to read. Whitehead challenges 8 warrants as overbroad and lacking in probable cause. Those applications are attached as Exhibit B through I and are as follows. A warrant signed by Magistrate Judge Jennifer E. Willis on June 17, 2022 for prospective and historical cell site location information and pen register information for a cell phone using call number ending in 9839. This warrant was signed after Whitehead falsely told law enforcement that he had turned over his phones. Okay, number 2, a warrant affidavit signed Magistrate Judge Valerie Figueredo on September 21st, 2022 to search the contents of that 9839 cell phone and another cell phone with the call number 3314. At the time the warrant was signed, the government had already obtained a warrant to seize and search these 2 phones for evidence of the conduct that ultimately led to the charges in counts 2 through 4 in the indictment. Wait a minute. At the time this warrant was signed, the government had already obtained a warrant to seize and search these 2 phones for evidence of the conduct that ultimately led to charges in counts 2 through 4 in the indictment. Oh, wow. So the information in that cell phone that they seized actually led to those 2 through 4 charges. Interesting. A warrant signed by Magistrate Judge Michael A. Hammer of the District of New Jersey to search iPhone seized on the person of Lamar Whitehead. This warrant authorized the government to search Whitehead's persons for any iPhones and to search these iPhones for evidence of the conduct that ultimately led to the charges in counts 2 and 3 of the indictment. So your own phones, Whitehead was getting you caught up. Thank you so much, Tarsha. I appreciate the super chat. A warrant signed by magistrate judge. Let me go down to 5. A warrant signed by magistrate judge Ona T. Wayne. There was a lot of different judges in here. November 23rd, 2022, for historical cell phone location information for the 3314 cell phone and a phone believed to be used by the son of victim 1. The warrant sought information between May 1st, 2020 and June 15th, 2021. The period during which Whitehead was dealing with victim 1 and her son regarding the fraud ultimately charged in count 1. Oh, so they seized remember we saw the text messages in the civil complaint that was attached. So apparently the government had already seized those phones that attached to the number that Whitehead allegedly used in those text messages. A warrant signed by Magistrate Judge Kathy L. Walter of the District of New Jersey on June 27, 2022, to search a home in Paramus, New Jersey, which the government believes to be Whitehead's house. The warrant was signed after Whitehead falsely told law enforcement that he had turned over his only cell phone despite retaining the 9839 phone and his used toll record, cell site location information obtained using the warrant attached to 9839 cell site warrant to show probable cause that the 9839 phone would be at Whitehead's home during overnight and early morning hours. A warrant signed by Magistrate Judge Michael Hammer of the District of New Jersey on December 16, 2022. Oh my goodness, all these warrants to search the Paramus residence. So his whole residence was searched. This warrant was obtained after Whitehead had been indicted by a grand jury sitting in the district and saw evidence of the crime sought in the original indictment and conduct the government was continuing to investigate. Finally, a warrant signed by Magistrate Judge Robert M. Levy of the Eastern District of New York on June 7, 2022, to search the location in Brooklyn, which the government believes to be Whitehead's church. The warrant application explains that Whitehead, who is a convicted felon, made a recorded statement that, quote, "I got guns in the church," end quote. The warrant saw evidence that Whitehead was unlawfully in possession of a firearm in violation of 18 U.S.C. The government did not recover a firearm during the search. There we go. Thank you again, Tarsha. I appreciate you. Jamil, thank you so much for the support. Thank you. Thank you, Keela Gang. I appreciate that. Okay. Let's see. So we go through the Fourth Amendment, talk about warrants. Let's go to the argument. Whitehead's challenge to the church warrant affidavit fails at each step of the analysis. He lacks standing to challenge them. He has not identified any error in the magistrate judge's probable cause analysis, and in any event, the government conducted its searches in good faith, reliance on the warrants. There is no basis for suppression, and the motion should be denied. First, Whitehead lacks standing to challenge the search warrants. Whitehead has not offered any affidavit or sworn statement establishing his reasonable expectation of privacy and any of the information sought by the warrants or any of the evidence recovered by the government. Although the government believes that some of the warrants concerned items in which Whitehead likely could establish a privacy interest, such as his home and phones, he has not done so through an affidavit. So he didn't even do an affidavit to attach to his motion. And they like, yeah, no. Thank you, Q the Prophet. I appreciate the super sticker. The law prohibits him from establishing standing based on the government's assertions which Whitehead implicitly challenges. For the other warrants, Whitehead likely could not establish standing if he tried, because he does not have a reasonable expectation of privacy in, for instance, the location data of someone else's cell phone. Accordingly, at least on the present record, and the court can deny Whitehead's motion at the threshold. So it has someone else's cell phone information. He was trying to suppress that too. Second, Whitehead has identified no defects in the probable cause articulated in the warrants. He acknowledged that his basis for suppression for all 8 warrants is the same. Thank you, Johnny Townsend, for the super chat. Oh my God. Wait a minute.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call
Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
Ooh, you guys, that just tickles me every time. Okay, let's get back to business here. Okay. You done lost my whole train of thought here. Second, Whiteheads has identified no defects in the probable cause articulated in the warrants. He acknowledged that his basis for suppression for all 8 warrants is the same. And the warrants share, quote, a number of allegations and factual basis. Yet, over the course of the investigation, 7 different magistrate judges across 3 judicial districts found that the warrants adequately demonstrated probable cause. Whitehead generally argues that the warrant affidavits were, quote, lacking in particularity or, quote, overbroad. These conclusory statements identify no manner in which any of the 8 warrants, much less all 8, were insufficiently particular or excessively broad. Whitehead raises a small number of specific objections, but each is unavailing. His primary argument is that the warrants rely on information from CS1, who Whitehead alleges is not trustworthy. We know who that is, guys. Every interview we talk about the setup. He talks about the setup with CS1. Whitehead acknowledges that the warrant affidavit did not ask any magistrate judge to rely on any of CS1's statements to law enforcement. He argues, however, that, quote, the tie to any kind of criminality comes from CS1 stating initially that Mr. Whitehead had allegedly stated that CS1 should go into business with him because of his close relationship with Official 1, end quote. As the warrant affidavit explains, however, CS1 statements are provided as context for later recorded statements made by White. So his statements are provided as context for later recorded statements made by Whitehead on which the court is asked to rely. That is, CS1's statement provides background and context for the relationship between CS1 and Whitehead, including how the government came to possess recordings of Whitehead, but the evidence of Whitehead's criminality are his recorded statements. For instance, that Official 1 would, quote, sit down with whoever I need him to sit down with. Oh, they got you recorded saying Official 1 would sit down with whoever I need him to sit down with. Or that, quote, we could make so much money together. It's unreal, bro. My connections, even with Official 1, but underneath connections. But bro, we gotta be all in. The warrant affidavits were explicit that they did not rely on CS1's uncorroborated statements for their truth. Whitehead also suggests that the affidavit in the 9839 cell site warrant is contradicted by other evidence. Specifically, he notes that an FBI report explains that Whitehead went to a body shop where CS1 works, but the, quote, warrant application states that the discussion occurred over phone calls recorded by CS1, but has no mention of Mr. Whitehead showing up, end quote. That is, Whitehead complains that the warrant affidavit said that Whitehead and CS1 discussed their fraud on recorded calls, but in truth, they also met once in person. This argument misses the mark for at least 2 reasons. The warrant affidavit at issue is explicit that it, quote, does not include all the facts that the affiant has learned during the course of this investigation, end quote. Nor is the fact that Whitehead and CS1 met in person once in any way to the magistrate judge probable cause analysis. Whitehead hardly suggests otherwise, saying only that the fact, quote, would seem to be important, end quote. Whitehead next specifically challenges the victim one cell site warrant because it relied on a civil complaint arising out of the same facts. Whitehead argues that the mere fact that a civil case was filed does not provide probable cause that a crime was committed. Probable cause is a much higher bar than required to file a civil complaint. End quote. Oh, they about to get him on this one. This argument too fails at each step, as the warrant affidavit makes clear it is not based simply on the civil complaint, but based on interviews with victim one and her son and the affiant, review of text messages between victim one, her son, and Whitehead. That victim one has sued Whitehead is not the sole basis for probable cause in the warrant, even though it actually could be. It is simply further evidence that Whitehead never lived up to his representation of victim one or returned the stolen funds. And in any event, a civil complaint can show probable cause, especially whereas here it is verified complaint containing detailed allegations. Although the beyond the reasonable doubt standard for the jury's decision in a criminal trial may be higher than a civil trial, there is no reason that detailed complaint could not meet the much lower bar of probable cause. Probable cause is like so basic. It's literally a crime was committed and you did it. So if you have a witness that says I was wronged, they stole from me and he did it, I'm evidence. I'm a witness. That's probable cause. I mean, it's the lowest of the lowest. You very rarely beat probable cause hearings because that's just how low it is. Now, of course, beyond a reasonable doubt is what has to be proven in a trial, which is something totally different. But to get you to that defense chair, that probable cause is a low bar. And in civil cases, you have preponderance of the evidence. They have different levels, but it's lower than what more likely than not in 50, 49, 51, that type of thing. But it's still probable cause is so low that I don't see why facts of a civil lawsuit wouldn't give you probable cause, because it's literally you did this to me and I'm the witness of that. So moving on. Finally, Whitehead challenges the June premises warrant, arguing that the warrant is overbroad as it is authorized the search of the entire house. That warrant, however, provided probable cause to believe that the 9839 cell phone was within the house, which was the premises to be searched, and authorized the seizure of just the phone. There is nothing unusual about the issuance of a search warrant for a house, and Whitehead provides no authority for the proposition that a warrant need be any more particular than that. And there's the case law. Third, even if Whitehead identifies some defect in the magistrate judge's finding of probable cause, the court still should deny the suppression motion. For each of these searches, law enforcement brought its evidence of probable cause to a magistrate judge and relied in good faith on the warrant signed by the judge. Many of the warrants incorporated by reference the probable cause from a prior warrant or repeated that probable cause and substantial similarity, as Whitehead notes, and were yet again approved by a magistrate judge. The warrants are not a wholly lacking in support that law enforcement could not have reasonably relied on them. Let me see what this footnote said. Whitehead also claims that this interaction with victim one are in dispute over a business deal that did not pay dividends and is a matter for the civil courts. That argument is not an issue for this court. It is also wrong. Acting with intent to defraud, Whitehead abused his position of trust and lied to victim one in order to steal her money. That is criminal fraud, as a grand jury found. Whether and additionally gives rise to civil liability is a matter for the civil courts. So now the third basis, they were asking for a Franks hearing, and we went over there in that video if you guys missed that. I would like to be there playing the theme song from the 70s television. What's happening since he looks like Ron? You know what? Like Ron. based on the preponderance of the evidence here, he's guilty beyond a reasonable. I agree. The Fifth Amendment is your friend. Let's just stop talking. I agree with that. But this is his motions, though. So, I mean, he gotta. So let's go. This is the last part before we get to he actually replied to this motion. So a search warrant affidavit is presumed reliable. In certain circumstances, however, a defendant may challenge the truthfulness of factual statements made in the affidavit and thereby undermine the validity of the warrant and the resulting search or seizures. Under Franks, to suppress evidence obtained pursuant to an affidavit containing erroneous information, the defendant must show that 1, the claim inaccuracies or omissions are the result of the affiant's deliberate falsehood or reckless disregard for the truth, and 2, the alleged falsehoods or omissions were necessary to the issuing judge's probable cause finding. The defendant must establish both components, materiality and intent, by a preponderance of the evidence. The intent component of the Franks inquiry, which looks to the mental states of mind of government officials, is said to be a subjective test rather than objective test. So then you have all of this case law. Even to merit a hearing on the issue, a defendant must make a substantial preliminary showing that a deliberate falsehood or a statement made with reckless disregard for the truth was included in the warrant's affidavit and the statement was necessary to the judge's probable cause hearing. Let's go to the discussion. So you guys generally know in order to have a Franks hearing, there has to be these prongs that are satisfied that shows that there was some type of inaccuracies or falsehoods in the affidavit that issued the warrant. So anyways, discussion. Whitehead's request for a Franks hearing fails at every possible step, but one point is dispositive. A Franks hearing serves to determine the credibility of the affiant on the warrant. Whitehead does not and could not challenge the credibility of the affiant on the warrant's FBI Special Agent Ford. So a Franks hearing is for the affiant, which would actually be the FBI agent. He's trying to do a Franks hearing based on what we've been hearing about for the last several weeks about how Belmonte basically is not credible. Instead, he asked for a hearing to examine the credibility of an informant, CS1, who was discussed in the warrants. That is a legally improper purpose to request the hearing, and Whitehead's motion should be denied solely for that reason. Then it has all the law. It has a lot of it, as you guys see in parens. Whitehead's motion also fails at multiple other thresholds. For example, even with respect to CS1, Whitehead does not make allegations of deliberate falsehoods or reckless disregard for the truth, accompanied by an offer of proof. Whitehead's proffered excuse for this is absurd. He claims that he does not know the identity of CS1. But as discussed above, CS1, identified as victim 2 in the indictment, is well known to Whitehead, as the court has repeatedly found. Moreover, the assertions attributed to CS1 in the warrants are based on conversations with Whitehead. And so even assuming Whitehead had somehow forgotten with whom he had spoken and refused to review the videotapes recording those conversations, videotape to record those conversations, he has firsthand knowledge about the accuracy of the statements in question, and far from being suspect that the affiant to the warrants asked the reviewing magistrate not to rely to CS1 statements is also dispositive of the Franks motion. To obtain relief under Franks, the defendant must show that the alleged falsehoods or omissions were necessary to the issuing of the probable cause finding, where the affiant expressly told the issuing judge not to rely on CS1 statement. Whitehead cannot hope to show that CS1 statements were necessary to the finding of probable cause. For all the above reasons, Whitehead does not to advance this case by citing People v. Darden, even assuming that state case, because mind you, we're in federal court, even assuming that state case had some application here, Darden provides a device for an in-camera inquiry of a confidential informant whose identity is unknown to the defendant in order to examine the credibility of law enforcement officer who relied on the informant. But here, number one, Agent Ford's credibility has not been called into question. 2, the informant's identity is known. 3, Agent Ford specifically did not rely on the informant. And 4, no allegations of deliberate falsehood or of reckless disregard for the truth accompanied by an offer of proof have been made, even with respect to CS1. Whiteheads legally misguided and factually baseless Frank's motion is thus entirely without merit. So that was that. So that was the government's response to his motion to basically it's like, kick rocks, get this out of here. You guys, please hit that like button and please subscribe if you haven't done so already. Sweet Diva said, just prolonging the inevitable. You said he can keep talking. Oh gosh, you guys are hilarious. I hope my internet holds on. It keeps going in and out. Okay, so now these responses aren't as long as these replies, I don't think. Let's see. I told you we was gonna be here for a little minute because I didn't go over this before. So the motion to, so this is Whitehead's response. Is this his response? Oh, yeah. Motion reply pursuant to the federal rules, Rule 12. So he says, the government has not made a showing that the motion to suppress the statement should be denied. The argument that Mr. Whitehead was in custody, even though he was not arrested, is correct based upon the facts. Individual was considered seized for the purpose of invoking constitutional protections against unreasonable search and seizure when, by means of physical force or a show of authority, his freedom of movement is restrained. More specifically, the Supreme Court of the United States concluded that a person has been seized within the meaning of the Fourth Amendment if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to go. So they're still saying that even though he was able to, for 20 minutes, go in and out freely in his house and go scroll through the phone and write down numbers and call whoever he needed to call, they still trying to say he was under arrest. He still believed he wasn't free to go anywhere. The phrase, the rights mentioned in Miranda still apply, may be slightly unartful, but it is not, as the government contends, contrary to black letter law. So they basically said the fact that they said the rights mentioned in Miranda still apply, his attorney is basically saying it wasn't worded very well by saying it's slightly unartful, but they don't believe that it's contrary to the law, what they're trying to say. Like they may not have came out right, but it's still not contrary to the law. So the Supreme Court discussed the concurrence by Justice White and Terry v. Ohio. So when you have a concurrence, when an opinion comes out, you have the opinion by the majority of the court. You have some people that join it, and you have some that want to do a separate opinion. Because oftentimes they may agree with the conclusion, but they would have gave a different analysis. So when they talk about the concurrence, it's just the judge that wanted to do their own separate opinion and not be on the main opinion. Stating that in the context of a Terry stop, which is not custodial, the person stopped is not obliged to answer the questions put on them by police. While there are important differences in the specific application of rights in a custodial, non-custodial situation, a person has rights such as the right to remain silent. Okay. Let me move on. The reliance on Bobby v. Dixon is misplaced. The facts in these cases are not at all similar. And Dixon, the defendant, had a chance encounter with police on November 4th. All right. In addition, this situation mirrors that of Sullivan v. Texas and Salinas. An individual came to a police station willingly to speak with law enforcement and what was explicitly not a custodial interrogation. The Supreme Court eventually ruled that it would have been a simple matter for Salinas to say that he was not answering the officer's questions on Fifth Amendment grounds. Further, Salinas states that a witness's constitutional rights to refuse to answer a question depends on his reasons for doing so, and courts need to know those reasons to evaluate the merits of Fifth Amendment claim. The reason for not answering questions here was known to the government, and it's clear that the defendant stated he did not want to speak with investigators without an attorney present. He specifically, clearly, and unambiguously invoked his right to counsel. While these rights are not unqualified outside the custodial situation, an individual can clearly invoke them as discussed. The fact that Mr. Whitehead requested counsel is not in dispute. The report in Bates number 1502 clearly states that Whitehead decided he did not want to speak with investigators without an attorney present. At this point, law enforcement should not have spoken to Mr. Whitehead without counsel present. It should be noted that the statement that law enforcement searched the home on that date was erroneously included. Law enforcement did not search Mr. Whitehead's home on the date. The error was an accident with no bad faith intended, for which counsel does apologize. Counsel contends that the error is not relevant to legal matters raised in this motion. So basically, she's agreeing that when that search warrant, it was just for the phones, like we just discussed, and what the government said. And now she's like, oh, yeah, I accidentally put in there that it was a search warrant for the home. I didn't do it on purpose. I'm sorry to the court that I said that. And I probably shouldn't have put that in the pleading. I haven't even read this one. So let me see it. Let me see if it's any phone numbers or anything in here, because I try to block them out, even though they got them plastered everywhere. I'm gonna just read it because I didn't go over this, so I don't want to. I kind of skimmed through the other one, so I was able to block it out, but this one I didn't really go over at all, so I just pulled it up. The government's allegation that one of the cell phones related to the false statements does not pass muster, given that the falsity of the statement given is at best disputable. According to the report written by Special Agent Ford related to that date, agents asked if Whitehead had another phone he could be reached on so the agents didn't have to stand in his driveway. Whitehead responded that he did not. S.A. Ford asked a second time, stated, you don't have a second cell phone that belongs to you that we could call you on? The emphasized sections are important here. The question, do you have another phone, is fundamentally different from, quote, do you have another phone that I can call you on, end quote. For example, any number of individuals may have a work phone and a personal phone and decline to give out the personal number. Let's read that again. So, according to the report written by Special Agent Ford related to that date, agents asked if Whitehead had another phone he, quote, and they have it in like italics, he could be reached on so the agents didn't have to stand in his driveway. Whitehead responded that he did not. S.A. Ford asked the second time, stating, you don't have a second phone that belongs to you that we could call you on? The emphasized section are important here. The question, do you have another phone, is fundamentally different from, do you have another phone that I can call you on? For example, any number of individuals may have a work phone and a personal phone and decline to give out the personal number. The statements that the defense have not shown reckless disregard for the truth by the affiant is not correct. The affiant took the strange and unique step of specifically stating that CS1 should not be relied upon. The only rationale the defense counsel can think of for doing so is that there is some issue with CS1's credibility, so severe that it would imperil the warrant. It shows reckless disregard for the truth and submit a warrant affidavit based upon the individual that the affiant obviously does not trust, thus is buttressed by the fact that such great lengths are gone to regarding the lack of Belmonte / CS1's credibility should give any court pause. This is relevant because such information was not available to the magistrate. The statement that we do not know who CS1 is could most accurately read that it was not confirmed who CS1 was. All right, let me pull this up because y'all out it. Oh my goodness. Right, the word salad. The statement that we do not know who CS1 could most accurately read that it was not confirmed who CS1 was, for which the impact is the same. Counsel was not able to make a representation that CS1 is a particular individual before that has been confirmed, even if there is a very strong supposition. The idea that by stating that CS1 should not be relied upon, the government can just avoid the issue is troubling. It would allow the government, through a simple footnote, to essentially invalidate the reckless disregard for the truth language from Franks by putting in a footnote stating that a particular individual who is the source for at least some information should not be relied upon only proof of deliberate falsity. The government states where the affiant expressly told the issuing judge not to rely on CS1's statement, Whitehead cannot hope to show the CS1 statements were necessary to the finding of probable cause. This is incredibly troubling. If an individual is not trustworthy, if they cannot or should not be relied upon to provide probable cause, why is the government using that individual as a source of information? The government further claims that Agent Ford specifically did not rely on the informant. This is not correct. Agent Ford asked the magistrate not to rely on the informant. Agent Ford obviously did, considering that the investigation was predicated on CS1 coming to law enforcement. Further, the idea that even if these warrants were flawed, which they are, that they are covered by the good faith error exception is incorrect. The affiant knew that there were issues with CS1 and specifically stated they should not be relied upon in making a finding of probable cause. This is not within the good faith error. So it's all about Belmonte. The affidavit submitted here provided no evidentiary basis for the court to conclude that Mr. Whitehead's phone was involved in or would contain evidence of criminal activity. The affiant alleges that criminal activity was afoot on the basis of a confidential informant, CS1, who is not trustworthy. Footnote 3 of the warrant affidavit states in relevant part, the government is not asking the court to rely on CS1 statement to law enforcement in making the probable cause determination. Counsel cannot recall another case where law enforcement explicitly asked the court not to rely on the statements of the confidential source. While the affiant alleges that a number of the allegations supporting the affidavit are based on recorded statements made by Mr. Whitehead, the tie to any kind of criminality comes from CS1 stating initially that Mr. Whitehead had allegedly stated CS1 should go into business with him because of the close relationship with Official 1. The basis for the warrant affidavit is an individual that the government specifically asked the court not to rely on. It must be asked why the government contends that CS1 should not be relied upon. If CS1 is trustworthy and reliable, why not ask that the court rely upon those statements in making a probable cause determination as the government does in countless cases? Or why not leave the issue unaddressed? Why specifically and explicitly ask the court not to rely on these statements? It is not unreasonable for an individual to conclude from these statements that there is some issue with the trustworthiness or veracity of CS1 and or statements they have made to law enforcement here or in the past. In addition, it is an impossibility to ask the court to ignore parts of the warrant affidavit. The government is essentially asking the court to selectively read the affidavit rather than read and rely upon the entire document. If this information should not be relied upon, why was it included? Additionally, CS1's information, including uncorroborated information, is all over the application in this case by counsel. Count CS1 is mentioned 53 times in the 19-page application here. Yet the government contends that CS1 should not be relied upon. CS1 cannot or should not be relied upon. Then how can the information serve as the basis for the warrant? I'm sorry, you guys got to sit through this with me. As a result of the lacking particularity and facts to support probable cause, the warrants in this case should be controverted and the evidence seized thereby suppressed. Any renewal of said warrant is similarly flawed. The information leading to any renewal was based on information gained from the prior warrant. Since any evidence recovered pursuant to the initial warrant was illegally seized, any renewal is based upon illegally seized information and should likewise be controverted as fruit of the poisonous tree. When evidence has been seized in violation of a defendant's constitutional rights, the remedy is for that evidence to be suppressed and inadmissible at trial. Matt v. Ohio. This extends not just to the direct results of the unlawful search or seizure, but also to the fruits. The exclusionary prohibition extends as well to the indirect and direct products. The warrants that are the subject, this is C, motion for an in-camera inquiry regarding CS1. The warrants that are the subject of the motions made herein were based, at least in part, on information furnished by an individual identified as CS1. Counsel believes that the issues related to the respect for an in-camera inquiry regarding CS1 have been sufficiently brief. Counsel intends to maintain any issue or point raised in the initial motion papers that is not addressed in this reply. And they want to make additional motions. All right. So then the government today did what they call a surreply, which is not always the court. You have to get permission for that. And so they said, "Dear Judge, the government respectfully requests permission to file this letter in surreply to defendant Lamar Whitehead's motion to suppress his false statements to law enforcement. In the defendant's reply, he argues for the first time that even he was not in custody at the time he made the false statements, concedingly rendering Miranda inapplicable. The Fifth Amendment still precludes admission of those statements. As explained below, the defendant's argument conflates separate principles of Fifth Amendment law and should be rejected. On the one hand, the government agrees that if an individual expressly invokes his right to silence, then that invocation cannot later be used against him, regardless of whether he was in custody at the time. Then it has law. On the other hand, the defendant cites no case law for the proposition that an individual's non-custodial invocation requires suppression of subsequent affirmative statements made by that individual. Indeed, such a rule could not be squared with the Supreme Court's holding that law enforcement is permitted to question an individual subsequent to a non-custodial invocation. To the extent the defendant invites the court to ignore this rule by misrepresenting the nature of his interaction with the agents, reply 3, it is worth noting that the agent's questions about a possible second phone occurred only after the defendant had freely engaged with them for close to 20 minutes in an effort to contact someone to open the Brooklyn search location. Throughout this time, the defendant's movements were unrestricted, and he was free to and did leave the presence of law enforcement. The defendant can hardly be described as having been coerced or badgered. Indeed, he could have terminated his contact with law enforcement at any time. Instead, he freely chose to lie to them. Finally, it should be noted that the Supreme Court has repeatedly held that neither the text nor the spirit of the Fifth Amendment confers to a privilege to lie. Brogan v. United States, rejecting exculpatory no defense to false statements charge. An individual may choose to remain silent, but he may not lie. It cannot be thought that as a general principle of our law, a citizen has a privilege to answer fraudulently a question that the government should not have asked. Our legal system provides methods for challenging the government's right to ask questions. Lying is not one of them. A citizen may decline to answer the question or answer it honestly, but he cannot with impunity knowingly and willfully answer with falsehood. The Second Circuit has likewise repeatedly held that neither the Fifth Amendment nor any other constitutional provision protects lies. Hashtag lies. The operable term here is lies. You cannot lie under no circumstances to the feds. Smith argues that her perjury charges must be dismissed because the government, this is just what this case has a proposition for. In United States v. Smith, Smith argues that her perjury charges must be dismissed because the government did not warn her of her Fifth Amendment right against self-incrimination under her Sixth Amendment right to counsel. This argument fails because even assuming a violation occurred, it does not entitle Smith to a dismissal of the indictment for perjury. Then it gives a whole lot more law similar to that. And that's it. And that's their third reply. And that's what was filed on today. I'm going to look at a couple of your comments and then we're going to hop up off of here. If you have any questions, just throw them in the chat regarding the alleged robbery or even the indictment, and I'll try to answer them to the best of my ability in the next couple of minutes before we get off here. Told you guys we're going to be here for a little minute. Usually I try to keep it under an hour, but we've been on for almost an hour and a half. Thank you for all 500 plus that have been rocking with me this whole time. Make sure you hit the like and make sure you subscribe if you have not done so already. Yeah, you can't lie. That's all they're saying. You can't lie. If he is lying about something as simple as do he have another phone, he lying about a lot more. This is just our commentary. All of this is our commentary. Read the description. This is our opinion. We know that these are just pleadings. The judge has not provided an order yet, so we don't know how the judge is going to rule. But of course, when the order comes down, we will all be discussing that as well. Thank you for all of the super chats and super stickers and all that today. You guys make me feel good. As your social media lawyer, I am apparently famous on YouTube in New York. Thanks to you guys and all of your support. Thank you, Faith Speaks, for the Cash App. I thank you so much. Oh, Alice. Say it ain't so. Say it ain't so. They should know that when the junkyard dog mouth is open, his greasy lips are moving.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
That's a good question. I'm sure they may have. I don't know how the feds do it, but they may have body cam. And I was opined that they probably did for this situation, even if they typically don't. So. Man, I don't know why I like this clip so much. This clip is hilarious to me. But anyway, thank you guys for joining me. As we get new information, you already know I'll be on here to give it to you first. I have to run. I have a couple of things to try to do before 5 o'clock, which is like in 30 minutes. So until next time, I am going to holler at you guys later.